According to AARP, 60% of Americans lack proper estate planning. Do you have an effective strategy in place to ensure that your final wishes are carried out in your absence? Is your strategy actually going to work? What happens when you become disabled? Who will make decisions for you in the event you're deemed incompetent? Advice from a world-class elder law attorney on how to plan your estate and how to protect your hard-earned assets. Learn how to develop and implement a proper strategy before it's too late. All of this and more when we return from this commercial break.
A will can only work, or a trust can only work, if everything else that you do is in line with those two items. Okay? So a will is a document you write to let the world know where you want your stuff to go. And a trust is a detailed instructions of what happens when you become disabled or when you die.
We're here in studio with Lisa Salinas Mondello. You saw her in the workshop. I got to tell you, I think she's probably the #1 expert when it comes to estate planning. So I've asked her to come in the studio so we can dive a little bit deeper and learn a little bit more about wills and trust, and do you need them, and if so, why? Tell me why I might need a will.
Well, Chuck, people use wills to tell the world where their assets are going to go.
Okay.
Anything that's titled in your name, like your car, for example, when you die, it goes through probate. Probate's a process when you have to file paperwork at the court.
Right.
You have to file accountings, and then the probate asset, like your car, goes to whomever you've named in your will. Most people don't like probate because they don't like the fees, they don't like the time, they don't like the aggravation, so they like to avoid probate. So if you don't have a will, they're going to decide where your property goes. And that's what's called the law of intestate. So for example, most people think if they're married, everything automatically goes to the spouse.
Right.
Well, that doesn't actually work that way. The spouse only gets a certain percentage of the estate.
I didn't know that.
Based on how long they're married. For example, in North Carolina, the spouse is allowed the first $30,000 worth of assets outright.
Okay.
So as long as that car is worth less than $30,000, we know she's going to get that absolutely.
Right.
Most people have an idea of where they want things to go. Now, let's say it's a second spouse.
Right.
Maybe you want your assets to go to your children.
Yeah.
Maybe you don't want your spouse to get any of those assets, or maybe you want your spouse to just have income, and you want to save the principal for your children. So the will, if you use a will, it has to be very detailed about what your objectives are.
Okay. Very specific.
Very specific about what your objectives are. You want family harmony. So you want to be thinking about, how do I keep family harmony? Well, the best way to do that is make it clear. The more instructions that you can leave your family, the better you have harmony. In fact, some people will enter into what's called a family harmony agreement. So before they even die, they have their children all sign a family harmony agreement that says, we agree that we're not going to bicker when mom and dad die, and we're going to accept whatever they do.
I heard, and tell me if I'm wrong, Lisa, I heard that if an estate involves $100,000 or more, there's a high incidence of lawsuits between siblings and heirs. Is there a high percentage of people that get into family fights over inheritance?
Here's the issue. That it's very easy to file what's called a will caveat, saying, I don't like the will. So it's very simple. If you don't like something and your nose is bent, go ahead and file. It doesn't really cost very much. But it does cost a lot of money to defend that. And that's why sometimes people are going to think about using a trust. Let's stay out of the probate court. Let's keep it private. And let's make our wishes known to our beneficiaries, but we're going to keep things so that we're not in probate court with will caveats being filed.
Do you need a will and a trust, or does a trust replace the will?
That's a good question. So a trust can stand on its own. And sometimes a trust could be used to go in line with a will. For example, let's say that you die, you don't have enough money to pay your funeral.
Right.
And you owe the funeral home money, or you had a MasterCard for $300 and you didn't have enough money to pay them.
Right.
A creditor can always file their own probate. And so if they file a probate, they might be looking to your trustee for you to pay those last expenses if you haven't made arrangements.
Do people, when they go from one state to another, do they have to change their trust or their will pursuant with the laws of that state?
Well, typically if your will was executed properly in the state in which it was signed, then the state in which you move to is going to respect that will.
Okay,
it's
good.
going to allow that. But you should always, of course, check the state in which you move. So in North Carolina, your will, if it was executed properly in New York, will be allowed in North Carolina. So if you needed 2 witnesses and a notary and you did it, you're good.
Good.
If I move to another state with a trust, it may make sense to move the situs or the home of my trust to the state in which I live.
Right.
That might have something to do with taxes or where your real estate's held. And so that's really a simple adjustment to the trust in most cases.
Yes.
If the trust was drafted well.
Let me ask you a question about a will. Can I just go home today and write up, I give everything to my wife and my daughter and my son, and does that hold up in court? Do I need witnesses? Do I need an attorney? Can you write a simple will?
Sure, you can write a will.
And it's legal?
And it can be legal. Now, whether you're going to have problems with that is another story, but yes, you can.
Okay,
Should
not
you?
recommended, but
Yeah.
you can do it.
Yeah, that's right. So people will say to me, well, I've been giving my children $15,000 a year every year, all the kids, all the grandkids, so I'm not really worried about Medicaid counting it because I can give this money away, right? Well, that's not how it works. So if you ever want to take advantage of Medicaid to help pay that cost of care, they're going to look at your assets for a period of 5 years. They're going to go back, it's like an audit, to see what you gave away. So even though the IRS is going to allow us to give away $15,000 or over $11 million, I mean, does anyone have an $11 million problem? Okay, all right. But if you do, don't worry, we can help you out. But so people will give away money. And the way that it works is if you give money away and then ask Medicaid to help supplement your cost of care, they're not going to do it. Because if you're going to give money away, you have to plan how you're going to do it. It has to be within the rules. So they do have some rules about giving money away. Now, am I suggesting that you give your house to your children? Absolutely not. I mean, if I give my house to my children, my son, and then he's married and he gets divorced, who owns my house? His wife. If I give it to my son, he gets a car accident and something happens and he gets sued, who owns my house? So giving our house to our children is not really the best thing to do. Because to protect your assets, you have to protect them from unknown predators, unknown creditors. And when we add another person as a joint account holder or a title holder, we now are exposing our assets to their creditors, their liabilities. So we need to protect it.
We're back with Lisa Salinas Mondello, who is an expert in elder law. In fact, she's only one of approximately 14 experts designated in the state of North Carolina. So what you tell us, we can take to the bank. I want to talk about what you just talked about in your workshop. Let's explore this whole business about medical rights and giving people power of attorney over our health care. Mm-hmm. So I'm in an accident and I'm in a coma. I presume my wife would have the authority to act on my behalf with or without a directive. Is that true?
Let's say without the directive first. So if you don't have that directive, that health care power of attorney, then there is an order that the state's going to go to your wife, to say, what do you want to do?
Right.
But the problem happens is what happens if the kids don't like what your wife's saying? Or what happens if your wife isn't in line with what the hospital says?
So when you're healthy and you're lucid, you should direct what action you want taken.
That's right.
When you're not able to make the decisions yourself.
That's right.
And that's called a health directive.
That's called a health care power of attorney, also called a health care directive or a health care proxy.
Okay.
Those words are mainly, they're used interchangeably depending on what state you're in. Now, the problem sometimes arises when people name folks to be their health care power of attorney or health care agent.
Yes.
Because maybe they're the oldest child, the youngest child, the child that lives closer.
Right.
But they're not choosing someone who can do the job. And I can remember a case that I was involved in where a woman named her daughter to be her health care agent. And the woman had dementia at the beginning stages. She lived on her own. She had a nurse that would come and take her out. She traveled on airplanes, would see her family, drive a golf cart, shop, go to Belk's, eat lunch out. And then she had a medical event. And when people have dementia or other disabilities, if they have a urinary tract infection,
right,
let's say, their symptoms are going to be worsened. So she ends up at the hospital. Then she ends up at rehab, then she ends up at a nursing home. So the daughter calls the family and says, listen, mom's not going to make it. You should come and say your last goodbyes. So son comes up from South Carolina to go visit his mom.
Sure.
Mom is at a nursing home, strapped to a wheelchair, drooling and in a diaper. She can barely move, and all she can do is turn her head and say, help me.
Help me.
That's it. Son is infuriated, so he goes to the healthcare agent and says, get her out of there, this place is killing her.
Sure.
A few months ago, she was visiting. She came on a plane, she drove the golf cart, she went to lunch. What the heck's going on? Healthcare agent said, you need to accept this. The son was a professional. He said, no way. I'm going to fly my mother to South Carolina, where I'm going to get her the proper care. We're going to take care of this. The healthcare agent didn't want that to happen. So before things started to get out of control, we went to the document. Let's see what mom thought when she wrote this document with her attorney.
Sure.
And it said, if my healthcare agent isn't doing a good job, child number 2, which is not the child in South Carolina, has the ability to remove my healthcare agent.
But that's a subjective thing, Lisa.
That's right. That's right.
I mean, how do you know whether she was doing a good job or not? I mean,
that's one, you have to convince that person that has the power. Hey, I don't think she should be in the nursing home. I don't think she should be strapped to a chair. I don't think she should be over-medicated.
right.
I think she needs to get out of this place. So in fact, child number 2, with some convincing, did remove the healthcare agent, and child number 3 in South Carolina became the agent. Moved mom, took her to South Carolina, and within 2 weeks she was walking, talking, she was toileting herself.
What were they
She was back to going to lunch and doing her
to
thing.
her in that place?
Although-
Maybe over-medicating.
Yeah, they're not supposed to medically restrain a patient. It's not allowed. But unfortunately, it does happen. And so in this case, naming a backup plan, putting checks and balances in such a crucial document, changed the woman's life. It saved her life.
Yeah.
And gave her quality of life.
So everybody needs a medical directive, don't
Absolutely.
they? Now, let me ask you this. A medical directive, is the hospital obligated to follow what the medical directive dictates?
Okay,
Even if it's contrary to what they think is right?
Yes and no. So a living will is a directive.
Right.
I don't want life support. Boom. That's a directive. Listen to that.
Okay.
A healthcare proxy, healthcare power of attorney, is a document that either gives directives on what I want to happen in a situation or gives discretion to my agent.
Yeah.
So really making it clear as to what you want is so very important. And so just downloading a form from the internet isn't going to do that.
I would think that there's built-in problems with respect to multiple marriages and children from multiple marriages. Mm-hmm. Am I wrong?
There are built-in problems, and that's why the documents are that's why that handwritten will probably won't work. And that's why having documents drafted by somebody who's competent, somebody who understands your family dynamics, the difficulties, so they can build safeguards in so that you're not in litigation. It's because even if there's litigation, even if the person would lose, it's very costly.
Right.
And that's why sometimes people just settle cases because they don't want to deal with the litigation, which is unfortunate. And this is where family harmony agreements sometimes come in.
Yeah.
And that way you can kind of get those things out on the table.
That's
at
a
the
great
get-go.
concept. I love the family harmony agreement. I want you to give me 3 things that every viewer on our show today needs to know.
I would say the first thing is financial power of attorney. Absolutely, every person 18 and over should have a financial power of attorney, because if they do not and something happens to them, then the state is going to appoint someone to be their guardian of their money.
Now, who is that?
That's a public guardian, depends on the county. And it's typically a lawyer, and they're going to get fees, and those fees could exceed 5% maybe. Maybe they're taking 5% and then they're hiring their own law firm to then charge to do more work. So the bigger your estate, the more you're going to pay.
Right.
You might not like that,
Right.
right?
Right.
So you name a chain of command. You name a chain of command of who is going to manage your money for you, and that's critical. And the healthcare power of attorney, like we talked about,
Yes.
critical again, because you need to know who's going to make healthcare decisions for you, where you live, who's going to visit you, what you eat, what your life is going to be like and what kind of dignity you're going to live in it.
Right.
And that's really important.
Yes.
So I would say those are the two most important things. And then the third part of that is to make sure you're communicating with your financial power of attorney and your healthcare agent to make sure they understand what your desires are, so that they're not supplanting what you want with what they want.
Right.
And you know, Chuck, here's the other issue. When you're doing those documents, the parents will say sometimes, I'm going to name both my children as co-agents because I want them to work together, right? Because when they were kids, they did great together. The only thing is you were the umpire then.
Right.
Now you're gone, you're sick, something's happened.
Yes.
And when they can't get along and they can't agree on the
What
decisions,
happens then?
the court steps in and puts a guardian in. And it may
We're
be,
back to the guardian.
We're back to Department of Social Services now controlling your health care, where you live. Yeah, I mean, one time I had a lady that she could have lived in her home until she died with 24-hour care, no problem. But Department of Social Services became her healthcare agent. It's too hard for them to monitor that. If people want things to go a certain way, they have to make it clear. It should be in their documents. It should be written exactly what they want. We sometimes do personal care plans for our clients. And in personal care plans, when you talk about, hey, I want windows.
Right.
Hey, I want to watch football on Sundays. I want a glass of wine on Friday nights.
You put that in a document?
Put that in a document. I like going to the movies. And I want to see my family and be cleaned up for that as long as I'm not a burden to them.
Yeah.
And I want to travel for holidays to go see my family because I have money. So I want to use my money to do that. So I want to put that in a personal care plan that's a directive, because if I have a stroke today, someone might be coming to my house that doesn't know that I don't like mayonnaise. And when I throw the sandwich at them, I may end up somewhere I don't want to be because I couldn't communicate it. So I need that.
I always used to say, Lisa, that I wanted to live long enough to be a burden to my children. I'm just kidding. I'm just kidding. Okay. Is there anything else that our viewers have to know before this program is over?
Mm-hmm. It's great to have an estate plan. It's great to have a will, maybe a trust. But if your plan's not funded, if your plan hasn't been completed, it isn't going to do you any good. The stack of documents you have cannot do a bit of good unless everything's been done from soup to nuts.
Right.
And so when you look at the stack in front of you, do you know what your documents do, what the trigger is, and who the folks are that are going to help you, and where your backup plan is? Do you actually know? Have you read your documents? When's the last time?
Now, it's been probably 5 years in my case. Mm-hmm. And you mentioned that you shouldn't put an automobile in a trust.
Yeah, I don't like putting the automobiles in trust because it's a depreciating asset. Also, because we're talking about a lot of title changes. So if I die in my will, I'd rather just give that vehicle to my spouse or have it sold rather than having it retitled over to a trust and the trust distributes it to a beneficiary.
Got it.
Just more expense.
You know the other thing I learned, Lisa, is let's say the car is in a trust, I get into a car accident, now the trust is potentially liable.
It could be liable. And so you don't really want to
That's a big one.
That's a big one. Also, when you're talking about vehicles, whether you want to have your trust lien the vehicle and then give it to somebody as a way to insulate as well.
Okay. All right, listen, thank you so much. This has been enlightening as always. We're going to be talking a little bit more about this estate planning. I know it's important to our viewers no matter what their age. And this is, if you're young, you better know this stuff. Mm-hmm. And you better start thinking about laying your plan of action out. And if you're older, you better have a will or an irrevocable trust or a revocable trust, and you need to know the difference. And you especially, you said it at least 5 times, you better have a medical directive.
That's right.
Thanks so much for being here today.
Thanks for having me.
You know, we spend a lot of time deciding what our career is going to be. We spend a lot of time planning marriages and all sorts of affairs throughout our lifetime. We need to dedicate just a little bit of our precious time planning for those final arrangements and making arrangements for when we're ill and when we can't represent ourselves and our own needs. Hopefully today's show gave you a lot of insight relative to how to plan for the inevitable. None of us are going to be around forever, but we certainly want to make sure that when we do leave this earth, we leave it exactly the way we want to leave it in terms of our assets and taking care of those we love. If it matters to you, it matters to us. We'll see you next time.